Hey guys, my name is Matt. I'm the owner of Tails channel here. This is my channel. Hello if you're new, and I'm just quickly giving an introduction to this video. I'm right here. So this is basically a copyright informational stream. We want to just help you guys out with the new YouTube changes coming up. I mean, we already got some copyright changes on December 3rd, but starting in January, they're going to start the monetization reviews, which is basically reviewing if you don't have any copyright in your videos. So everyone has to watch out for that. So I thought making this video with Mike Pollock, the voice of Dr. Eggman, the Pokemon announcer, and a bunch of other things, as well as Gordon Firemark. He's basically a entertainment lawyer. He's also the author of the podcast, blog, and New Media Producers Legal Survival Guide. You can check out both of their websites in the description. We just want to help you out, and yeah, that's pretty much it. So go ahead, please enjoy, and thanks for watching. All right, let's go.
Hi, everybody. I'm Mike Pollock. You might know me as the voice of Dr. Eggman and several other anime and animation-related characters, but that's not really why I'm here. We're here today to discuss copyright and how to respect copyright on YouTube. You may have seen me in message boards and stuff complaining, "You're violating copyright by posting bits of games." And people got on my case and said, "You can't tell me what to do." I can't really tell you what to do, but I can at least suggest things you might want to do to, stay out of jail. So, I, and Matt, the guy behind Tails channel, who was getting into it with me earlier, decided, something, maybe we should invite an expert to discuss the subject of copyright. So we've done just that. Matt, why don't you say hello and tell us a little bit about yourself?
Oh, hello. My name is Matt. I'm the owner of Tails channel over at YouTube. What happened to me was I uploaded all the Sonic Lost World cutscenes. You know the game from Sega, the new one,
I've heard of it.
and just Mike helped and suggested that I would take it down, and things led to another, and we just wanted to do this to inform you all about copyright and also the new copyright rules coming on December 3rd. This may help you a lot, and we just don't want to see you guys get in trouble.
Exactly. It's a public service. And our resident expert for today is Gordon Firemark. Gordon, tell us about yourself.
Well, hi, everybody. I'm Gordon Firemark. I am an entertainment and media attorney from Los Angeles, California. I've been practicing in the field for about 21 years, and I hope I have some valuable information to share with you folks today.
Excellent. Let's kick things off. What is this thing called copyright in a nutshell?
Well, copyright is one of the components of the category of law that we refer to as intellectual property. The others are trademarks and patents and trade secrets, and there's a few other sort of side flavors, if you will. Copyright is the one that is sort of most prominent in most people's minds, and that's what we're going to talk about. What a copyright is essentially a bundle of rights that the owner of the copyright has the exclusive right to make copies of the work in question, distribute them, make derivative works based on the original, to display or perform the work in public if it's a performance kind of a piece. So ownership of a copyright is a valuable property right, and yeah, it's actually covered in the Constitution. So this is something folks were thinking about in the 1700s, and here we are a few hundred years later, and still talking about it.
So it existed well before YouTube was even a thing.
Yes.
Excellent.
That's pretty amazing, actually.
Now, is everything ever created automatically protected by copyright? For example, if I were to write a short story in my free time, can I copyright that?
Well, the threshold for protection under copyright law, in order to get this bundle of rights that I'm talking about, you have to create something original. So it has to have a modicum of originality, and it has to be fixed or recorded in some sort of a tangible form. So the act of writing down something, a creative work like a short story, yeah, once you do that, you are entitled to the protections of the copyright law for that work. And there are no specific requirements that you register anything or file anything with the government, or put any particular notice on the work. It used to be, prior to 1989, there were requirements for the notice and things like that, and earlier law even required a registration. But in order to be consistent with the rest of the world, the U.S. Joined the Berne Convention, which is the International Copyright Law Treaty, and now all the signatory countries, 165 of them, have pretty much the same rules. So original work of authorship fixed in some tangible form, you've got a copyright and you're entitled to this protection.
So the average guy in his bedroom writing a short story has just as much copyright protection as, say, a video game publisher or a movie producer.
Yeah, almost the same amount of protection. There are some benefits that one gains by recording and registering the copyright. That tends to be more on the if you ever need to sue kind of benefit. But yeah, everybody who creates works of authorship is entitled to these protections.
Okay. Now, a lot of folks figure I bought a game, I must have the right to post it on YouTube. And when I do, I will post a disclaimer that says, I don't own this copyright. All rights belong to whoever actually created it. Does that do any good?
No, in fact, it's worse than not saying anything at all. I think I would refer to that as a smoking gun. You know, and I'm not a litigation attorney, but I'll certainly, if I'm going to go suing somebody over an infringement and they've posted, I don't own this copyright, and what I see is no infringement intended is the common one. That's the first thing I'm going to wave around in court. You knew it was protected, and you used it anyway. You should have known better. And yeah, so I think those are silly.
Now, some companies, whom shall remain nameless, but some I happen to be occasionally involved with, seem to be rather tolerant of fan art. So they let fans draw stuff featuring the characters that they've created and make, I guess, what would be derivative works with them. Is a copyright holder obligated to protect their copyright wherever it might be infringed?
You know, they're not obligated to protect it everywhere against every little thing. There is a principle in the law that suggests if you don't exert your rights, if you don't exercise your rights, eventually you lose them. You know, sit on your rights and they'll go away. But it is often enough for the copyright holder to just sort of say, we know what you're doing and we're okay with it. You know, that's almost as good as to protect one's rights as going after someone for infringing.
Now, there's the side issue of cheap knockoff products like Ricky Rouse and Monald Muck, to steal a line from The Simpsons, that show up in cheap little dollar stores, for example.
Yeah.
Is that's not quite copyright, but it's a similar concept, I would imagine.
It's a related concept. Is one of those other intellectual property components that I was talking about. Trademark law deals with the marks, brands, distinctive indicators of source or origin. And what we're talking about there is what's referred to as counterfeiting. So yeah, counterfeit goods that you'll find, you know, of a particularly well-known mouse or duck, as you suggest. Those are a real big problem that the owners of those brands work hard to protect against. Now, there is an element of copyright in there as well. So somebody who's trafficking in those kind of counterfeit goods might expect to be sued not only for trademark infringement, but also for copyright infringement. And by the way, these laws do have a criminal component. So the folks that are doing it on a large scale might expect to also end up looking at some jail time, possibly.
Now, there is sort of, I guess you would call it, a loophole, the magic of fair use. What's that about?
Fair use. There's nothing magic about it. It's actually it's a defense to copyright infringements. The first thing I want to say is, if you are relying on fair use, understand that you're really only going to get to argue about fair use after you're being sued. You're going to be in court. You're going to be paying lawyers to do the arguing for you. And anybody who's ever been anywhere near a courtroom before understands that it's not an inexpensive, simple, or easy process. So if you're looking at fair use, I mean, it's possible to conclude that something is a fair use. Let me explain what fair use is. Because the copyright law restricts people's ability to use and build upon works that are, you know, created by others, it, by its very nature, impairs the freedom of speech of the people who want to use those other people's works. And so we have a conflict between the First Amendment art guarantees of free speech and the protections of copyright that are also covered in the Constitution. And so the courts over the decades developed this doctrine of fair use. And when the Congress um, revised the Copyright Act in the mid 70s, it actually adopted that fair use and created this formal defense. What it says basically is, if you're taking small amounts of a work and using it for, socially beneficial purposes, and so, there's this 4-factor test: the amount and substantiality of what's taken, the nature of the infringing work, the nature of the original work, and also the impact on the market for the original. And you sort of mash those all together and look at a balancing of, how does it weigh out? Is it fair use or is it infringement? And unfortunately, there's no, bright line rules on this. You have to do the analysis on a case-by-case basis for each alleged infringement. So yeah, so it is a way out from a lawsuit for copyright infringement, but there's going to be a lawsuit before you get to argue about it.
And ultimately, the court would decide whether, yes, that in fact was fair use, or no,
Right.
you're going to jail.
Now, there are lawyers that, and we will be able to sometimes express an opinion on whether something is a fair use. And there is some law that says that a plaintiff complaining about copyright infringement has to think about whether it's a fair use. Otherwise, you're bringing a frivolous lawsuit, and that can have its own consequences for the plaintiff. So, it makes sense that if you think what you're doing is going to be is likely to be fair use, probably get a good opinion from a lawyer about that, and add that to the file so you have an argument to make. Yeah, that's my answer.
Okay. Let me drag Matt into the conversation for just a second. Matt.
Oh, yes.
There's a thing that gamers do, some of them anyway, a thing called Let's Plays, where they record footage of themselves playing a game. Now, would that just in and of itself be considered fair use because it's the game and there's someone actually playing it, or do they need to add commentary to make it more likely to be considered fair use?
Well, this is a tough question. In my opinion, I think it can be considered as fair use, but yet again, since you're talking over the footage that belongs to them, but still you're making it your own in a way, but that's still kind of pushing it, I guess.
Yes. At what point does it become a derivative work? Because the video is all the same, but there's additional audio added to it.
Yeah. My son loves to watch he's 5, by the way. He loves to watch the gameplay videos on YouTube of Angry Birds Star Wars.
Excellent.
And there's a guy who does great ones, and he's really narrating what he's doing, and we're going to try to accomplish this. And if I send, he's got strategy tips and so on and so forth. And the fact of it is, if the owners of that copyrighted work wanted to, I think they would have a basis for claims against these guys. Certainly to get the material taken down off of YouTube, and even if necessary to go to litigation about this. The answer is this, and I had this come up in a matter for a client not long ago. I'll elaborate in a minute, but I think that the game itself is a copyrighted work, and it consists of multiple works within it. So the music soundtrack from the Sonic the Hedgehog or the Mario Brothers, or I don't know, whatever game it is that you're looking at, and I'm showing my age, I guess.
Those are both still valid games.
Yeah. So the soundtrack is a copyrighted work in and of itself, as is the visual gameplay. Now, the fact of it is, remember I said that in order to be entitled to copyright protection, the work has to be fixed in a tangible medium. I have some question about whether or not the gameplay is fixed, because it's requiring user intervention to make it go the way it goes.
Right.
And
as opposed to a movie that's always going to be a movie and always going to look the same.
Right, and there's this movement called machinima. I don't know if you're familiar with that, where folks will actually take gameplay scenes from games and make them work a certain way, and then cut them together into a film telling a narrative story.
Machinima, yes.
Yeah. So
there you go.
One of the factors here in the fair use analysis is the nature of the infringing work, And some courts look very closely at whether or not that in new work is transformative. Does it take the original and turn it into something entirely new and different? And we like to say that has a social value. We're creating something new and valuable. I would say that merely talking over the soundtrack probably doesn't get you there, but the stuff that the machinima folks are doing, maybe it does. And the narration where you're not just talking over, but maybe giving a critique, a product review probably is transformative, and the nature of the use is different. So you have to look again at each individual gameplay video and figure out what is it exactly that's the intent here and what's going on. As a fact of the matter, most of these game companies don't mind these things being out there because it promotes the sales of the game.
Now, someone had once suggested to me that stealing video, which for the moment is, let's call it stealing video, is a way of promoting the material and, for example, promoting my work. And I draw a parallel of saying, can you go into a Best Buy, steal a TV off the shelves, and run out and show a friend of yours, look what a great picture this has?
Yeah, that's an apt analogy, I suppose. It's certainly effective rhetorical work going on there. Yeah, I mean, the fact of it is somebody went to the trouble and expense of creating that video, however great or little that expense and trouble was. Nevertheless, they went to some trouble to create it. And the purpose behind copyright law, this goes back to what I was saying is in the Constitution. So going back in 1789, there was a group of founding fathers who said, we want to provide an incentive to artists and inventors, creators and authors and inventors, they used. And the way we're going to do that is guarantee them for a limited amount of time the exclusive rights to the stuff they create. And that gives them a financial incentive. They can sell it, they can market it, and so this is called the Patents and Copyrights Clause in the Constitution, and it's the justification for the patent law as well. You invent something, you get to have an exclusive on it for a while, and then after a while, everybody else will get to use it. So, did I answer the question?
Yes, I think you did. Now, speaking of promotional things, companies often release promotional material like pictures or videos, a trailer, for example. Can you redistribute trailers and promotional images?
I think the same rules really apply generally, but in most instances, I think they actually encourage you to, promote using these things. Certainly with still photos with biographical stuff or whatever, or trailer, as you said. I think most of the time when you get that electronic press kit or when you go to the website where this stuff is living, there are actually explanations of what you can and can't do with it. And I guess what I'm saying is I want to encourage you to look at those things and read the fine print and find out what's okay and what's not. I think it's okay to use it if you're going to be reviewing the product or just talking about the fact that the product is about to come out. That's exactly what promotional uses are about. But if you're going to use it to create, a different kind of work of art, or if you're going to, I don't know, badmouth the product, maybe they're not going to be so happy about it. And I'm sure that there are lawyers in these companies that are thinking about this and articulating these license terms, these permissions in ways that give them some teeth if they need them.
These are the dreaded terms and conditions that everyone clicks on accept and ignores.
Right.
Yeah. Is there a legal distinction now that the internet is a thing between linking to an existing video versus re-uploading it to your own channel?
Well, linking to something and saying, hey, look over there at the stuff that they're hosting, that is a perfectly fine thing. There was early in the days of the internet, there was some discussion about deep linking versus linking to the top level pages and so on. And I think there's an etiquette about this kind of thing. But linking is okay because you're not making a copy. All you're doing is telling people where to find a copy. So,
good point.
Yeah.
Now, there are some things that can't be copyrighted. If I remember from my college course on the subject, song titles and recipes, you can't copyright those.
And that comes to the other component of the basis for copyright protection, that is that originality. The song title just isn't enough there in most instances to be entitled to copyright protection. That's not to say there isn't some other kind of protection available for them. I mean, I think if you wanted to create a new work and call it supercalifragilisticexpialidocious, the Disney folks behind the Mary Poppins movie would probably have a problem with that, and they would, they would find a way. I think it's more like trademark law, although trademark doesn't generally protect single works either. Recipes is the same thing. It's not original. This is it's almost like a mathematical formula. They're facts.
Mm-hmm.
Facts and ideas are not protected. It's the original expression of those facts and ideas. So while the recipe to use 2 cups of flour and 3 eggs and a cup of milk and this much vanilla and that much salt, that part of a recipe isn't protected. But if you weave that recipe into a few pages of narrative in a novel, the pages of narrative are certainly going to be entitled to the protection. But the fact is, you can't stop somebody else from republishing that chemical formula of the recipe.
So that's why Coca-Cola keeps the recipe in a safe.
That's right. They're relying on a different principle of law called the trade secret.
Mm-hmm. Fascinating. That's a video for another time, I'm sure.
Yeah.
Now, if I'm in violation of copyright, what does that mean? What are the legal repercussions? Do I get a cease and desist letter? Do guys come and handcuff me in my bedroom? What happens?
Well, all of these things may happen. The possibilities are fairly broad. If you are responsible for making an unauthorized copy or distributing unauthorized copies or making those derivative works that I've talked about, something like that, you are what's referred to as an infringer. You're infringing that copyright. And what that means is that you will be liable for damages, a money amount, damages suffered by the owner of that copyright. If you are lucky enough to get a cease and desist letter, one ought to take it very seriously and discuss it with an attorney if you think there is fair use or some other defense basis for something. But there's no law or no requirement in the law that the owner send an infringer a cease and desist letter or something like that. They can just file suit. That lawsuit is in the federal courts. They make a federal case of it, and that's where the term comes from. And you will need to mount a defense, and that means hiring a lawyer to the tune of 5 or 6 figures going in. So it can be a real problem. What I was saying earlier about the registration not being required, but that there are some extra bonus points, I guess you could say, for the folks that do register copyrights, is something called statutory damages, and that means that the owner of the work does not need to prove that they've actually been harmed, that their damages are inferred by the fact that the infringement happened and that there was a registration. So in other words, the world is on notice that someone owns this thing, and by taking it, we're presuming that you've caused some damage, and the judge or jury can decide on the dollar amount without reference to any facts to support that amount being appropriate or relevant to the situation. Now, in practice, they tend to try to be balanced and look at the overall how much did it really cost them, kind of an approach. But they also look at how much of a jerk was the infringer when it came down to talking about it and whatever. So the damages can be as little as $750 per infringement, and they can go as high as $150,000 per infringement. And then you get into questions about, well, how many works are involved, how many infringements are there, does each time the video is distributed count as an infringement, those kinds of things. So it can really add up pretty fast. And so that's one of the biggest troublesome penalties. Add to that if they've registered prior to the infringement, the plaintiff will be entitled to receive their attorney's fees as well. And as I said, that can rack up in the 6 figures quite easily. So you can be talking about a pretty severe penalty. As I mentioned earlier, also the copyright law and the trademark law do include criminal penalties for the most egregious kinds of infringements. And in addition to the money damages and the criminal stuff, there's the injunctive relief. You could wind up with essentially a restraining order against these things. That's actually the most commonly sought action by the court is, hey, Your Honor, enjoin them, prevent them from stealing this work anymore. and doing this kind of a thing. And yes, that's almost always a part of these cases as well.
So from an internet user's perspective, the basic choices are I'm willing to take the risk and I will risk violating someone's copyright, or better safe than sorry and let's just not try violating any copyrights.
Well, one thing I forgot to mention is that, the Digital Millennium Copyright Act, the DMCA, this is the takedown mechanism that we've, heard about. If you're running a YouTube or a Vimeo or any online service that hosts content created by other people, there's this interesting little safe harbor built into the law that says that if you have a mechanism for taking down work that the owners claim is infringing on their material, and you follow that mechanism and you do as you're asked to take it down, and then there's a counter notice process and a whole thing. You, the service provider, are exempt or immune from lawsuits for copyright infringement. So, of course, the YouTubes of the world have adopted these kinds of policies, and they do it. And so, most often, what's going to happen if the average internet user who are posting one of these, Let's Play videos, what's going to happen is you're not going to get a cease and desist letter. You're not going to get sued. What you're going to get is a notice from YouTube that we've received a DMCA takedown notice from the owners of this material. They've asked us to take it down, and we're going to do so. And then you have an opportunity to reply and say, well, wait, it's not infringing, and here's why. And then if the other side doesn't agree, and YouTube puts it back up at that point, and then if the other side doesn't agree with that analysis, then they are free to sue you. So that's another component of this and another possible remedy. The interesting thing also is that YouTube, for one, has established its own internal algorithms to identify infringing work, usually in the music area, as I understand it. And they will sometimes just take things down, on their own, or in the case of music, they often will monetize it and give the money to the owners of the copyrighted material.
Mm-hmm.
So,
could I butt in really quick?
Yeah.
Yes, that steers our conversation actually directly.
All right, cool.
Who, for our purposes, is represented by a derivative image of a certain well-known video game character. Matt, please.
All right. Usually when the creators of the content basically take it for copyright and they just tell you, oh hey, this is ours and whatever, they usually take it down and then give you something called a copyright strike. And when you have 3 of these copyright strikes, well, first of all, if you have even one, you can't live stream for 6 months. You lose a bunch of your privileges. Just everything bad's going to happen. And after 3 strikes, your YouTube account will be taken down forever. So that's an incentive to not get copyright strikes. And usually, you would get the copyright strike taken away at 6 months, like it's gone forever, you're okay now. But starting on December 4th, I believe, once you get a copyright strike, it's there forever, and that goes for all the channels you own on that IP address.
I hadn't heard the there forever change in the rules, but it doesn't really surprise me. YouTube doesn't want to be on the receiving end of lawsuits, and part of what the law says is that they have an obligation to stop repeat offenders. So, if that's what you're doing, and there's no legal justification for what you're doing, it's a problem. They do have an appeals process, well, not appeals, but you'll get a notice that they think that you've got some infringing material on your channel. Sometimes it's a takedown, sometimes not. That you have that opportunity to present your argument, which in most instances I would expect would be that fair use argument. And I believe the strike doesn't happen until, well, I should say the strike goes away if you succeed in that argument. So that may be an incentive to creators to do those replies to the takedowns. But I don't think YouTube wants to be in the business of adjudicating these things either. So we'll see how they handle it as this goes forward.
Would YouTube's position be somewhat analogous to the common carrier deal that telephone companies, back when they used to be a thing, when they say we don't take responsibility for anything that happens within our wires, any crazy conversations, we're just allowing the transmission to occur?
I thought I was the only person who remembered the common carrier exemptions, but
I'm a geek.
it's similar. Yeah, it's similar. Yeah, I mean, what they're doing is they're making sure that they're taking the right steps to preserve the safe harbor. They don't want to be defending lots of lawsuits from copyright holders. It's been they've had to defend, now for 6 or 7 or 8 years, a case brought by Viacom, the major media company that owns all kinds of television shows and stuff like that. And because you see a lot of clips from the Daily Show or MTV videos and things like that on on YouTube as well. And they have prevailed in that case, but it's been many, many millions of dollars of defense costs. So it's something that they don't want to have to keep dealing with.
Okay, as we start to wrap things up, because I think we've covered a lot of ground, Matt, any further questions before we begin our wrap-up process?
Hmm.
No is a viable answer.
I don't think so, actually. I think I learned everything I basically need to know to keep my YouTube channel running, pretty much. So, thank you so much.
Sure. I've got one selfish question all about me. I like to point out to people right after I point out that I'm not a lawyer and don't dispense legal advice that my employment contracts usually state that the work I do for a video game or a cartoon or anything is a work for hire, meaning essentially that I sign away all my rights to the voice work and to the finished piece. So legally, I shouldn't care whether people are stealing it and posting it online. But deep in my heart, I still feel like it's a part of me that's being given away for free, even though I've already been paid in full. Is that wrong? It's purely from a psychological basis, which I know is not your expertise, but is it wrong for me to still care?
I don't think it is wrong. I mean, I think it's important that creators have some sense of ownership or parenthood of the work that they create, and you want to take pride in the work you do, and part of that pride comes from knowing that there's value in it. Um, uh, just to clarify the work made for hire doctrine, this is basically saying because you are an employee or because you're under a contract that specifies this work made for hire, you never owned this work. It isn't yours. You are an instrument of the company that hired you. You're forgive me. Voice talent is an important artistic component of things, but you're an instrument. You're a tool that's being used to create this.
I'm an ingredient in the non-copyrightable recipe of the
Well,
world.
yeah, kind of. Yeah. So when you create it, you are actually creating it for that owner, that other company, the employer, and so they own it from the get-go. And but I do think that it's important to take a proprietary sensibility about these things, because actually, after all, your name is on it or your brand is on it, and yeah, I think that's a valuable thing.
And I'd heard, and I don't know if it's a myth, but Disney employees are required by their employment contract to seek out copyright infringement wherever they see it and alert their bosses.
I haven't read I haven't seen that in a Disney employment contract, but for an executive or anybody like that, I mean, some people it is actually their job to do that, but I think it's smart of an employee to be on the lookout for those kinds of things anyway. The Disney contracts, interestingly, Disney is one of the most notorious employers for reaching beyond the scope of the employee's actual job and claiming ownership of anything and everything they create, even if it's not part of their job. So let's say you're a janitor and you work in the Disney cafeteria, and you go home and you write a poem. The word is Disney will claim ownership of that poem. So even though that's not what you're working for Disney to do. And some of what I do as a lawyer is, of course, representing folks that want to negotiate or carve things out. I work there as a window washer, and by the way, I've created these characters, or I've got this other product line, and that kind of stuff. And it is possible to negotiate that stuff. So work made for hire is an interesting area.
Okay. And if you're that same janitor and you go to your kid's school and find a poorly drawn Mickey Mouse on the cafeteria wall, that can be between you and Disney, whether you rat out the school.
Right.
Excellent. All right, then, Gordon, I think we have pretty much covered it. We've explained at least why I've been speaking out on the occasional video comment about you probably shouldn't be posting video bits. And thanks for enlightening us. I hope we
Well, it's been my
kept
pleasure.
the kids of America's attention, the kids of the world's attention.
I
And
hope so.
touching globally, the people violating U.S. copyrights across the sea. What what legal standing is there to cover that?
Well, as I mentioned, there is this copyright treaty called the Berne Convention, and 165 countries have signed it. Actually, the U.S. was one of the last to sign it, but so the courts in other countries are supposed to uphold the copyright law the same, roughly the same way that we do. And so if you're a bad enough actor and you happen to be in some other country, don't think you're going to get away with it just because we're not going to come and get you where you are. Uh, the bigger the company that owns the work, the Segas, the Nintendos, the Sonys, and folks like that, they'll reach across the sea and come after an infringer for sure.
Okay, excellent. Thank you so much for your expertise, and you have
My
plenty
pleasure.
of it.
Thank you
Matt,
so much.
thank you so much. All right, thanks for watching. I hope we've managed to keep your attention, and we may have a follow-up, so please stay tuned. Bye-bye.